Hello friends, I am Vivek Nahadia. I am a chartered accountant, company secretary. You can contact me on cavivek68@gmail.com. I hope you find this video useful. Thank you for watching. Hi guys, let's do a quick recap of whatever we have studied. This is a rapid revision session. First question, we are discussing 40 questions, top 40 questions of the Labor Industrial Laws 1. History of trade union in India. It has started in Great Britain, then it came to India, and to study the history of trade unionism in India, we have to divide it into 3 periods. First period is period prior to the First World War, second period is period up to independence, and third period is post-independence period till now. We'll study the first period, that is period prior to the First World War. It was the initial stage, and trade unionists were harassed by the Britishers and they did not encourage them. So initial stage, what you have to write, these are first period, what you have to write, these are the initial stage, and it was harassed and discouraged by the Britishers. Then period up to independence, National Congress started supporting them, and it started in Bombay, Madras, Punjab. Post independence, major changes happened. The trade unions were supported, and there was collaboration with political parties. That's it. History of trade unionism in India, trade union movement in India. It started from Great Britain, then it came to India. For India, we have to divide into 3 parts. Period prior to the First World War, up to independence, and post-independence. Prior to the First World War, it was initial stage and it was discouraged by the Britishers, and trade unionists were harassed. Second stage is period up to independence. National Congress supported it. It started in 3 cities, etc., like Madras, one of the 3 cities, Bombay, Madras, Punjab, etc. And the third period is post-independence period. Trade unionism became stronger and it began to collaborate with the political parties. Then second question, definition of trade union. What is the definition of trade union? Trade union means any combination, whether temporary or permanent, formed primarily for the purpose of regulating relations between the workmen and employees, or between the workmen and workmen, or between the employees and employees, or for imposing any restrictions in trade, and includes Federation of Trade Unions. What is the definition of trade union? Trade union means any combination. The combination can be temporary or permanent. And what is the purpose of formation? Purpose is for regulating the relationships between the workmen, between the employees, and between the workmen and the employers. Registration of trade union. Appointment of registrars. Appropriate government appoints the registrars. Any number of registrars can be appointed. Then we'll discuss about the powers of the registrars. The memory technique is CD-RAT, powers of the registrar. C for cancellation, D for dissolution, R for registration, R for certificate of registration, R is for again returns, A is for amalgamation, and T is silent. Then we are discussing mode of registration. Mode of registration, 7 members go to the registrar and give the application. Application will be accompanied by 2 statements. The first statement contains the rules of the trade union. The second statement contains the following statements. What are the following details? The second statement contains details of the members, details of the office bearers, and the details of the trade unions. There are 3 important people in trade unions. First important person is members, then office bearers, and the trade union itself. The second statement contains what? The second statement contains the name of the trade union, objects of the trade union, list of the members, and list of the office bearers. The details are not mentioned when the list is given because the details are already mentioned in the statement number 1. Power to call for further information. When the 7 members go and give the application form along with these 2 statements to the registrar, registrar sees the papers and he has the power to call for further information from the members. In case he is satisfied, then he gives the certificate of registration, and certificate of registration is the conclusive evidence. So let us go through that. Let us revise this again. Registration of trade union. We'll discuss about the appointment of registrars, powers of the registrars. Appointment and powers, 2 points related to registrars. Then simple procedure as a story. 7 members going, giving the papers to application and 2 statements to the registrar. Details of the first statement, details of the second statement, and then registrar sees the papers and calls for further information. If he is satisfied, he gives the certificate of registration. This process is very simple, and the first 2 points are about the registrar, appointment, and his powers. Answer is completed. Then immunity is provided for the registered trade unions. 2 immunities are provided, civil and criminal. Civil contains following: civil liability, tortious liability, and agreement in the restraint of trade. For whom this immunity is available? For registered trade union, office bearers, and the members. The second immunity available is from criminal suits. From criminal suits means no office bearer or member of the registered trade union. Again, the criminal immunity is available to registered trade union, its members and its office bearers. If what is the immunity? If the agreement is to commit an offense, then they are liable. If the agreement is towards the objects of the trade union, then they are not liable. Dissolution of trade union, 7 members go and apply for registration, and 7 members go for dissolution also. The notice of dissolution is signed by the 7 members plus a secretary of the trade union and shall be sent to the registrar. The notice shall be sent within 14 days, within 14 days of dissolution. After dissolution, 14 days, within 14 days, the notice is given, not before dissolution. It does not require a prior permission. The notice must be given after dissolution within 14 days. There is a point which we will discuss further where prior permission is required, and that is for the lockouts. I mean the closure. So we'll reach that later. So within 14 days of the dissolution, the notice should be given to the registrar. The registrar is satisfied. He registers in the register that registration of dissolution is passed. So what is dissolution? Dissolution has only 3 points. 7 members and plus secretary signing and giving the application to the registrar. Within 14 days of the dissolution is the second point, and registrar writing in the register that registration of dissolution. Amalgamation of trade union. 2 or more trade unions joining. It's called amalgamation. At least 1/2 of the members shall vote, and 60% of the votes recorded should be in favor. 1/2 of the members should vote, and 60% of the votes recorded should be in favor. The registrar of the state in which head office of the registered trade union is situated may register the trade union. When they amalgamate, they have to fix a place which will be the head office. That head office registrar will register the new trade union. Collective bargaining, very simple concept. If one person goes, if you alone go and bargain from a seller, that won't be effective. If a group of friends go along and bargain with the seller, it will be effective. That itself is the concept of collective bargaining. Employer is superior, employee is weaker section, and a group of employees become stronger. What are the prerequisites of a successful bargaining? Collective bargaining is there must be a bargaining agent, there must be commitment from both the parties to resolve conflicts, the reliance must be focused must be on facts rather than emotions, and mutual recognition of rights and interests must be there. So collective bargaining is what? Concept is very clear. Group of employees going and bargaining with the employer. What are the prerequisites? Prerequisites are 4. There must be a bargaining agent. This is fine. Second is the mutually they must be interested to resolve the conflict. Third point, mutually they must respect or recognize the rights and interest. And fourth point is that the decision must be based on facts and not emotions. Definition of industrial dispute. What is industrial dispute? Any dispute between the employers and the employees. Any dispute between the employees, any dispute between the workmen, or any dispute between the employers and the workmen is called an industrial dispute. Difference between industrial dispute and individual dispute. Industrial dispute we have just now defined. What is individual dispute? A dispute of the employer with a single workman is called an individual dispute. But if a group of employees, workmen, or a union of employees support him, then it becomes a industrial dispute. What are the tests to determine whether a dispute is industrial dispute or not? It has to be supported by a lot of people. Second, a lot of people must represent it. Third, the support must be at the time of representation, not after. Fourth, there must be proof of support. Fifth, there must be community of interest. Majority of the workmen must show interest in individuals' grievance. So, difference between industrial and individual dispute. Industrial dispute we know. Individual dispute is about single person. What are the prerequisites or the tests? Tests to determine whether an individual dispute is a industrial dispute. We have, this is where you'll find it complicated. This is very simple focus. It has 1, 2, 3, 4, 5. It has 5 points. The first point is that that single dispute must be supported by a group. Second, it must be represented by a group. That support must be at the time of representation, not after that. Fourth, there must be proof of support. Fifth, there must be community of interest. That's it, very simple. Aims and objectives of Industrial Disputes Act. to prevent and settle disputes, maintain industrial peace. Entire country should develop, harmonize the relations, social justice, investigate and settle the disputes between the employers, between the workmen and employer and the workmen. Prevention of illegal strikes and lockouts, relief to the workmen in the matter of layoff and retrenchment, and collective bargaining. So all the points summary is acts or aims and objectives of the Industrial Dispute Act. Basically, what is the aim means they want to prevent and settle disputes between the employers, workmen among themselves, and the workmen and the employers, to maintain social peace and harmony and industrial peace so that the country develops. This is the common point. What is industry? Industry, there must be systematic activity, and that systematic activity must be by cooperation between the employers and the employees. What is the output of that cooperation or systematic activity? Is the goods and services, and the goods and services must be able to satisfy human wants. I repeat, there must be a systematic activity. Systematic activity is done by the cooperation between the employers and the employees. What is the output of the cooperation? Is goods and services. These goods or services, what is the use? They satisfy human wants. There are three immaterial things. What are the three immaterial things? Whether the employees or the workmen are employed directly or through agency. Second immaterial thing is whether the capital has been invested or not. And third immaterial thing is whether the activity has been done to earn profit or not. There is a proper case law, Bangalore Water Supply and Sewerage Board versus Rajappa. What was the case? The workmen filed a suit against the management. Management said that it was carrying a statutory duty and legal functions, but the labor court rejected the claim and said that the board was an industry and the Industrial Dispute Act was applicable. Whether hospital is an industry, there are different opinions, and ultimately the conclusion was hospital do not come in the definition of industry because it is a public utility service. Whether education institute is an industry, no, education institute is not an industry. Hospital is not an industry. Education institute is also not an industry. Whether research institute is an industry, no, research institute is also not an industry. Whether statutory corporations, government departments, are government departments industry? Yes, municipal corporations are industry because they work for business and trade. Triple test to identify industry. What is the triple test? This triple test is derived from the definition of industry itself. Just write the definition of industry. Systematic activity, cooperation between the employees and the employee for the production of goods and services, and fourth, to satisfy human wants. The above conditions are fulfilled, then it is called an industry. Triple test means what? Three tests. 1 point, human wants point is dropped. Human wants point is dropped, and the first 3 points are there. Systematic activity, service or production of goods and services, cooperation between the employer and the employees. What is a public utility service? Public utility service, we derive the answer from the question itself. A service, public utility service means a service which is useful for the public at large. A service which is useful to the public at large. Like railways, telephone, postage, power, light, water, etc. Defined workman. Workman has a very, very exhaustive definition. It means a person employed in an industry, simple. Workman means a person employed in an industry to do any type of work. Discuss the law relating to strikes under the Industrial Disputes Act. Strike means stopping of work by a lot of people, group of people, and they act in combination. And they continue the strike until the demands are fulfilled. What are the kinds of strike? We have a memory technique, GST hunger. G has 4 points. G, general strike. G, go speed, go slow. Gherao. S for sit down or stay in. T for tool down or pen down. H for hunger, hunger strike. 7 types of strikes. General strike is very common. Strike notice is given and strike is launched. Stay in or sit down strike, very simple. From the question itself, stay in means they occupy the usual positions, they sit down and do not work. Pen down or tool down means they sit down and do not work. Pen down means it happens in government offices, pen, banks. You can take the hint. Pen is mostly useful in banks. So pen down means it occurs mostly in banks and government offices. Tool down means tools. Tools are used in factories. Tool down occurs in mostly factories. Hunger strike is very common. The workers go on hunger strike until the demands are satisfied. Go slow means workers go, sit and work, but they work very slow. Go speed, workers go, sit, work and work very fast, but by wearing badges. Gherao, it's a Sanskrit term, they encircle the employer. According to legality of the strike, what are the kinds? First, we'll revise this, discuss the law relating to strike. Strike means a big group of people, workmen, large group of workmen in mutual coordination with a planned way. They stop the work, and this is called a strike. There are 7 kinds of strike. We have a memory technique: GST, hunger; G for general strike; G for go speed, go slow, Gherao; S for stay in or sit down; T for tool down or pen down; H for hunger strike. According to legality of the strike, what are the kinds? As per the legality, strike 3 types: legal strike, illegal strike, and unjustified strike. Legal strike means what? There is a proper procedure given. Whenever dispute arises, the trade union puts it before the management. Trade union takes the dispute to the management. If they don't get any response, then it approaches the appropriate government. If they don't get any response, they give a notice to the employer, strike notice to the employer. Employer, on receipt of the strike notice, informs the conciliation officer. The negotiations start. If the negotiations are not successful, then the trade union launches a strike from the date mentioned in the strike notice. This is called a legal strike. So what is the procedure of a legal strike? The trade union takes the dispute to the employer, no response. Take the dispute to the appropriate government, no response. Then they give strike notice. Once the employer gets strike notice, he gives it to the conciliation officer. Negotiations start. If negotiations are not successful, then they launch the strike. Illegal strike means if any of these conditions are not satisfied, then it becomes an illegal strike. What is unjustified strike and justified strike? Justified strike means what? It is legal strike and the proper procedures are followed and the reasons for the strike are also genuine. But unjustified strike is what? The strike is done only to harass the employer. The reasons are not at all genuine. When is strike prohibited in public utility service? What is public utility service? A service which is useful for the public at large. Industrial dispute which arises in public utility service is considered very seriously by the government. The appropriate government is bound to refer it to the adjudication by conciliation, and it is obligatory on the part of the conciliation officer to hold conciliation proceedings. Moreover, the regulatory provisions on strike and lockouts are very, very rigorous with regard to the public utility services. So whenever a dispute arises in a public utility service, appropriate government has to refer the dispute to the adjudication by conciliation ABC, and the conciliation proceedings has to commence as early as possible by the conciliation officer. We'll discuss the law relating to lockouts now. Lockout means it is a weapon in the hands of the employer. The employers declare lockout for over large number of employees, and this is temporary closure. The main point is it is temporary. Closure is permanent, lockouts are temporary. What's the difference between strike and lockout? Strike is a weapon in the hands of the workers, lockout is a weapon in the hands of the employers. On the basis of legality, strike is of 2 kinds, legal, illegal, and one more kind is unjustified. On the basis of legality, lockouts are of 2 kinds, legal and illegal. Meaning of the word standing order and procedure for certification of standing order. Standing order means employees and the employers mutually sit and decide the draft standing orders. When the draft standing orders are sent to the conciliation officer in 5 copies, the conciliation officer, I'm sorry, this is not the conciliation officer, this is the certifying officer. Conciliation officer comes into picture in the case of dispute. This is certifying officer. When the draft standing orders are received by the certifying officer, he checks whether the two conditions are satisfied. What are the 2 conditions? First condition, every provision should be covered which is specified in the 5th schedule. Second, the standing orders must be in conformity with the act. Then after checking these 2 conditions, the certifying officer sends a copy of the draft standing orders to the trade union and asks them to give their objections. After receiving objections from both the sides, he shall follow natural justice and certify the standing orders. After certification, general rule is that the aggrieved party, after certification, any aggrieved party can file an appeal against it. date of operation of standing orders on the expiry of 30 days from the date of certification. From the date of certification, after the expiry of 30 days, the standing orders become operated. Certifying officer should maintain a register of standing orders. Every employer must paste the standing orders at a prominent place. So standing orders are mutually discussed by the employers and the employees, and that these standing orders along with 5 copies are sent to the certifying officer. Certifying officer checks 2 conditions and sends 1 copy to the trade union and asks them to submit their objections. After hearing both the parties, the certifying officer certifies the draft standing orders. Any appeal can be filed if any party wants to file. Date of operation 30 days from the expiry of 30 days from the date of certification. Register of standing orders must be maintained by the certifying officer, and that certified standing orders must be pasted at a prominent place. Modification of standing orders. The standing orders can be modified at any stage before or after certification. Modification, if modification has to be done before certification, then the entire procedure that we have discussed earlier can be written here in the same answer. Only one last point can be added, which says that after hearing both the parties, the certifying officer may modify or alter the draft standing orders. Modification after certification. This has a general rule that once standing orders are certified and registered by the certifying officer, then they cannot be modified. This is a general rule. But they can be modified under 2 conditions. There is an agreement between the employer and the employee to modify. Second, 6 months have expired from the registration of the standing orders. So modification of standing orders can be done either before certification or after certification. Before certification, the procedure remains the same. And one additional point that we have to write is certifying officer, after hearing both the parties, may alter or modify the certified modify or alter the draft standing orders. Modification after certification, general rule is that it cannot be modified after certification, but if 2 conditions are satisfied, it can be modified even after certification. What are those 2 conditions? First, agreement between the employer and the employee. Second, 6 months elapsed. Model standing order, the question itself will give us the answer. Standing order which is just a model, that is, which is only an example. This is given by the government. Based on this example, the employer prepares his own standing orders. This example is nothing but the standing orders prescribed by the Act. So what are the contents of this model standing order? It specifies the working time, list of holidays and wage rates. Model standing order is the standing order which is the model or the example, the standing order given as an example by the Act. Based on this, the employer prepares his own standing order. There are the 3 main contents of the model standing order given by the Act. First, publication of working time, holidays and wage rates. Advantages of a registered trade union. It is a juristic person. It can sue and can be sued. It has perpetual succession. Acquire properties in its own name. Can contract in its own name. All the characteristics are of a company. Retrenchment. Retrenchment means discharge of surplus labor for any reason except these 5 reasons. Then it is called retrenchment. If retrenchment or discharge is done, if discharge is done because of these 5 reasons, then it is not called retrenchment. What are these 5 reasons? Punishment, voluntary retirement, age of superannuation, non-renewal of a contract, and ill health. Punishment, voluntary retirement, age of superannuation, non-renewal of contract, and ill health. Retrenchment is termination of surplus labor for any reason except these 5 reasons. Punishment, voluntary retirement, age of superannuation, non-renewal of contract, and ill health. Now we'll discuss the difference between the layoff and retrenchment. Layoff is temporary, retrenchment is permanent. Your industry stops functioning, your industry in retrenchment does not stop. All or a group of employees are refused employment. Laid off compensation is paid, here retrenchment compensation is paid, and the employees are taken back after the layoff period. In this retrenchment, it is not mandatory for the employer to take back the employees. So 2 main differences of layoff and retrenchment are layoff is temporary, retrenchment is permanent. After the layoff period, it is mandatory for the employer to reappoint the employees. After the retrenched period, it is not mandatory for the employer to reappoint the employees. Works committee, if two conditions are satisfied, then a works committee should be constituted. What are the two conditions? First, it must be an industrial establishment, and second, there must be 100 or more workmen. Two conditions, it must be an industrial establishment, and second, there must be 100 or more workmen. Then works committee must be set up. So how is the constitution of works committee done? Representatives of employees and representatives of the employer both from the works committee. Condition is that the representatives of the employees should not become less than the representatives of the employers. And how are the representatives of the employees selected? By consultation with the trade union. Why is this works committee constituted? To prevent and settle disputes. Number of members, maximum number of members is 20. Term of office of the members is 2 years. Meetings once in a month they should meet. So works committee, two conditions should be satisfied. It must be industry, 100 or more workmen. Then the employer must constitute works committee. What consists of works committee is representatives of employees, representatives of employees. The condition is that representatives of employees should not become less than the representatives of the employer. And how are the representatives of the employees selected? They are discussed with the trade union. What is the object of the constituting the works committee? Is to settle the disputes and promote industrial harmony. Number of members are 20. Term is 2 years, and the meeting is once in a month. What is conciliation? For conciliation, we'll split the answer in three parts. First is meaning of conciliation. Second part is authority set up and conciliation, and third part is public utility services. What is the meaning of conciliation? There is a dispute between the employer and the employee. A third party comes up, who is a conciliation officer, and he gives a balanced conclusion after hearing both the sides. This is conciliation. Authority set up, there are two authorities set up. One is the conciliation officer and the second is the board of conciliation. Third is public utility service. Under the act, the conciliation is compulsory in respect of disputes arising in public utility services. So what is conciliation? Conciliation we divide into three parts. First is definition or meaning of conciliation. Second part is the authority set up in conciliation, and third part is public utility service. Meaning of conciliation means there is a dispute between the employer and the employee. They refer the case to the conciliation officer, and conciliation officer hears both the parties and gives a balanced conclusion. And the decision is given in the form of an agreement. Second part is the authority set up in conciliation. The first authority is conciliation officer, and the second authority is the board of conciliation. Third part is public utility services. If dispute arises in the public utility services, then conciliation is compulsory, mandatory. Voluntary arbitration. The employers and the employees voluntarily go and settle the dispute by way of arbitration. They prepare arbitration agreement. Then the arbitrator hears the dispute and gives the arbitration award. Arbitration award is nothing but the judgment, and this arbitration award is given to the appropriate government. Unfair labor practice. Unfair labor practice means the practices which are not fair. These practices are listed in the 5th schedule. This saves the workers from the exploitation of the employers and saves the employers from the harassment of the workers. So the 5th schedule is divided into two parts. First part is on the part of the employers. The second part is unfair labor practices on the part of the workmen or the trade unions. First part on the part of the employers. Many points are there, but the overall concept is that depending on the trade union activities, the employer cannot remove an employee, cannot transfer the employee, or show partiality towards him, or punish him. On the part of the workmen or trade union, unfair labor practices are illegal strike, or they go to the residence of the employer, they damage his property, or any act of violence. Victimization, the name itself suggests that a person becomes a victim of the another, and the person is workman, and workman becomes the victim of the employer, and the employer harasses the workman because of his trade union activities. Recovery of money due from employer. There is a settlement between the employee and the employer, and some money is due from the employer. Then the employee himself or by a representative can approach the appropriate government. Appropriate government gives a certificate to the collector, and this collector goes to the employer and collects the due as if it was arrear of land revenue. Principles of natural justice. Principles of natural justice are not any legislative enacted law. These are the judge-made laws. There are basically 4 principles of natural justice. First one is nobody can be a judge in his own case. Second, no one shall be condemned unheard. Third, the person who hears the discussion, he only can give the judgment. Fourth, a party is entitled to know the reasons for the decisions. Closure. Closure is permanent closing down of the place of employment. What is the procedure? Employer has to take prior permission for closure. In dissolution of trade union, we said that after the dissolution, within 14 days, the notice has to be given to the registrar. In closure, before the closure, prior permission has to be taken by the appropriate government. So the employer has to apply to the appropriate government, mentioning the reasons for closure, even give a copy to the registered trade union. On receipt of the application form, appropriate government scrutinizes it. It gives reasonable opportunity to all the interested parties. The appropriate government does an inquiry, and if satisfied, it passes an order for closure. This order is sent to the employer as well as the workman. The order will be binding on all the parties. Review of order can be done by the appropriate government on its own motion or by an application received. If the closure is done by the employer without permission, it is called illegal closure. Compensation on the closure, every worker is entitled to receive compensation. Labor courts, appropriate government constitutes labor court, and appropriate government puts one person for management of the labor court. What are the qualifications of that particular person? He was a high court judge, district judge. Third, he has held judicial office for 7 years, presiding officer for 5 years. So 4 qualifications: high court judge, district judge, judicial officer for 7 years, presiding officer for 5 years. Disqualifications are 2. He is not an independent person and he has attained the age of 65 years. What are the powers of the labor court? Labor court, the presiding officer gives a notice to the premises, and after giving notice, reasonable notice, he enters the premises for inspection. Labor court will have the powers of a civil court, and all the members of the labor court are public servants. Conciliation officer. Appropriate government appoints conciliation officer and they act as mediators between the dispute. What are the duties of the conciliation officer? He fixes a date, place and time for both the parties. He meets both the parties and settles the dispute. What are the powers of the conciliation officer? He is a public servant, he has to follow natural justice, and he has the powers of a civil court. Court of inquiry. Court of inquiry is constituted by the appropriate government. What is the purpose? They investigate into the facts. It is a fact-finding body, but it is not a permanent body. It is a temporary body. The main point is that if the proceedings are pending before any conciliation officer or labor court, the rights of the parties are affected. That is, the workmen cannot do strikes during that period. But if a proceeding is pending before the court of inquiry, the workmen can do strike even when the proceeding is pending. Domestic inquiry, the name itself suggests this is inquiry done internally. The management constitutes a disciplinary board. Disciplinary board appoints inquiry officers, and these inquiry officers inquire into the misconducts of workmen. What is the necessity of setting up this disciplinary board? The reasons are, for every misconduct, the management cannot go to the labor courts as it is very costly and time consuming. Employer cannot make allegations against his own workers. He cannot terminate his own workers whenever he wants. Inquiry report. These inquiry officers investigate or make inquiry against the workmen. After their findings, they submit the inquiry report to the disciplinary board, and disciplinary board takes decision on the basis of this inquiry report. What are the contents of this inquiry report? It contains a summary of findings on the charges of the accused. Contents are details of the accused employee, details of the witnesses, details of the allegations made, evidence in writing, and it must be given in good faith. What is a charge sheet? Is a sheet containing of charges against an employee. Charge sheet is a sheet containing charges against the employee. What are the contents? Details of the employee, details of the employee, details of the complainant, details of the witnesses, details of the allegations made, and 3 points in addition: it should not be vague, evidence must be given, and it must be fair. Hypothetical statements must not be given. Disciplinary proceedings in industries. Disciplinary proceedings means set of rules, practices followed by the industry. Management cannot take disciplinary action the way it wants. It has to follow some prescribed guidelines or procedures. These are called disciplinary proceedings. These are written and step-by-step process for removal of an employee. These procedures should be followed, and that procedure should be followed by the management. If the management fails to follow such procedure, then it may result in legal penalties against the management. What is adjudication or compulsory adjudication? Steps for settlement of disputes. There are 3 steps: conciliation, arbitration, and adjudication. Conciliation, arbitration, and adjudication. Adjudication is again divided into 3 kinds: labor court, industrial tribunal, and national industrial tribunal. Minimum wages are the lowest wage rate below which the employer cannot give the salary to the workmen. These are the basic necessities are provided, plus a few comforts like education and medical benefits are given, and the employer is bound to give this minimum wages irrespective of his profit. Thank you for watching my videos, friend. If you find my videos useful, please click on the like button just below the video. Click on the subscribe button. It is displayed in the red color as shown here. Third step, click on the bell icon to get notified when I upload new videos. When you click on the subscribe button, it turns white color and this icon will be displayed. Click on the bell icon. With this, when I upload new videos, you will be notified automatically. Thank you so much.